Next on the outline, I talk about the importance of the PIP case. And obviously what I'm really talking about here is some definitive period of time off work, some definitive period where they're submitting for replacement services, and I'm obviously also talking about the need for continuing medical treatment. And if you're out there and you're kind of scratching your head and you're saying, you know, doesn't Kreiner really punish those people who are really most worthy of our respect and our help as a community and society? The people who don't stay off work unnecessarily but might try and go back even if they're having severe pain, or people who don't necessarily run up unnecessary medical bills or submit replacement services unnecessarily. The answer is yes, clearly. I think the public policy implications of Kreiner are just horrible. And even though the Supreme Court has said that no one factor is dispositive, what have we seen already? Clearly, in a very ambiguous opinion of 63 pages that has very few hard, bright-line rules, judges are turning to things like time off work. We've seen them use the plaintiff's lack of submittal of replacement services to throw out cases, a short duration of medical treatment to find that plaintiffs have not met threshold. And I think that's really, unfortunately, where it's going. And there's not much as a plaintiff attorney you can do about it except just communicate to your client, unfortunately, what Michigan law really is today, and that these are things that they have to be concerned about. I do think it highlights the importance of pre-suit. And pre-suit, what I mean by pre-suit is having someone at your firm who is making sure that the plaintiff is submitting replacement services, that the plaintiff is treating, documenting their injuries, getting diagnostic tests, that there is some period where the plaintiff is off work. And I don't know, and we'll find out in the next year, whether that will be 3 months, 4 months, 5 months, 6 months. If Schuette and Sauter are on the panel, maybe longer, I don't know. But I think you have to have someone really looking and analyzing these cases before you file a lawsuit, because you have to make some very hard decisions. It's not just about helping people who are in pain and who need your help, about getting them to the right doctors. It's about making sure these cases survive. You know, what I tell my office is we live in a Blue Care Network world. And by that, I mean, in case you don't know, in Blue Care Network, they actually assess the primary doctors, I think, $400 at the end of the year for every MRI that they prescribe. You know, and these doctors are extremely reluctant to do it. And it really creates some huge challenges for us as plaintiffs in terms of how we're going to get these people the medical treatment that they need and the testing that they need when you have primary doctors in the HAP system or Blue Care Network that are kicking and screaming to make referrals. And frankly, you know, when I'm watching Mike Moore speak on, you know, some of these cases where you now have a 1-year statute, for example, Rory, how the heck can you actually show, how do you even know what some of these injuries are when you have clients in some of these managed care systems and these doctors are just doing everything they can not to refer out to specialists or for MRIs or, you know, try and get a HAP doctor to refer someone out to a neurologist when they're having headaches. They just won't do it. So, you know, for us as plaintiff attorneys, it means you have to get involved. It means you have to be talking to the treating doctors. You have to talk to them about their treatment. You have to talk to them about their referrals, or you make your own. George mentioned footnote 17 on page 28. I think that is frankly the most dangerous part of Kreiner for plaintiff attorneys. That is the area where we're talking about the self-imposed restrictions versus the physician-imposed restrictions. And, you know, when I read that, you know, you always want to have respect for the institution and for the robe, even if you might not like the people who wear it. So, you know, it's just fictional. It's make-believe. There's There's no basis for reality to it, and frankly, I think it's the second most bewildering thing I've seen this court do. The first, by the way, was in Lugo, where the same justice who authored Kreiner happened to mention that someone who trips on a pothole has a very minimal risk of harm or injury, when coincidentally the CDC says that's actually the greatest cause of death of the elderly in America. And in that one sentence seemed to wipe out about 60 years of human factors science in Michigan. So I guess you don't want to be blind or old in Michigan right now. But I looked at this footnote 17 that talks about self-imposed restrictions, and you just have to wonder if these justices have ever practiced a day of personal injury in their life. Maybe if you are a sitting justice on the Supreme Court and you have the best medical insurance and the best doctors, they will patiently sit down with you and make a long list of restrictions of things you cannot do. Most of my clients, on the other hand, seem to wait at least an hour just to get in to talk to their doctors, and if they're lucky, they're able to ask maybe one question while the doctor is already dictating their chart note and walking out of the room. And what do they always say about restrictions? What do they always say? If it causes pain, don't do it. So we have real life, and then we have footnote 17, and it's going to cause, I think, a lot of problems for plaintiff attorneys. So what do you do about it? Hopefully you explain it to the judge the way I have to you, but I think another solution might be looking at vocational testing and functional capacity testing. I don't have a lot of time. I did a whole seminar on this for the MTLA about 4 or 5 years ago, but basically in a nutshell, it's really amazing what they can do. They can take what may seem to be very minor injuries that may be very hard to show impairment, and by using some very well-supported tests, and these are tests, by the way, from the U.S. government, from the Social Security disability testing on low back pain, from the American Medical Association on pain and impairment. And every lawyer out there who does this kind of work, I think, should have the AMA guidelines for the evaluation of permanent impairment, which is in its 5th edition, came out in the year 2000. And just commit to memory pages 373, 374, and 400. You know, what they can do is they can literally take almost any injury, and by using very well-supported tests, they can come up with a long list of 40, 50, 60 things that your plaintiff either cannot do at all or can only do with the most extreme pain. And if you're a plaintiff attorney, what do you do with that list then? If he's a certified vocational examiner, I personally think that list can stand on its own, or consider taking that and sending that to the treating doctor or to the plaintiff IME to see if they concur. And if so, you now have a 40 to 60 numbered list of physician-imposed restrictions. And I think that's one way that we might be able to get around that, footnote 17.